Good afternoon. My name's Clarence from Trosho Law Office, PC here in New York City. This is part 4 of our series. This episode is important because of the rapidly changing landscape, especially in this subject matter. I'm talking about the Presidential Proclamation, suspending the entry of immigrants and non-immigrants that could pose a risk or a threat to the labor force during the COVID-19 outbreak here in the United States. I'm talking specifically about two principal proclamations or presidential proclamations. 10014 last April 24, 2020, 10052 subsequent proclamation as of June 24, 2020, and also its amendment June 30, 2020. As you could see, there's so many changes and it evolves and changes so rapidly that there's a need to discuss this. Now, essentially, the proclamation suspended the entry of certain people as immigrants or non-immigrants all the way to the end of this year until December 31, 2020. So what's covered? People who are covered under H1, H2, J, and L visa. What are the specifics? So those people who are, number one, outside the United States, under those categories. Number two, who don't have a valid non-immigrant visa under those categories. Again, that's H1, H2, J, and L. And people who don't have a valid travel document under those categories during or at the time of the proclamation or effectivity of the proclamation. There are exemptions. Green card holders, lawful permanent residents. If you're coming from outside, obviously you could come in. Number two, children and U.S. Spouses of U.S. citizens. Meaning if the U.S. citizen spouse is petitioning for their U.S. wife or husband or children, the visas could still be issued and they could still enter the United States. Number three, people who are considered essential to the food supply. And number four, people who are considered to be essential because of national interest as may be determined by the Department of Health and Department of Homeland Security. If you note, green card holders are the only ones who could enter the United States. So that means, therefore, that the petitions that they filed for their family members that they have been waiting for quite some time, unfortunately, is covered by this suspension. But some people would consider it as a ban. So meaning no visas could be issued for them. Interviews could be canceled until further notice, because technically this proclamation is subject to review every 60 days. And this could potentially and indefinitely be prolonged. Now, in terms of numbers, they're saying approximately 525,000 people under those categories potentially could no longer travel and enter the United States. Second, approximately 20,000 employers would be deprived of the opportunity to engage the services of people who are essential to their business, such as computer experts, programmers, things like that, or probably even to some extent companies who might need them that are also related to the COVID-19 outbreak here in the United States. Now, as we speak, last week, July 17, a lawsuit has been filed against the proclamation and its implementation by people who are affected by this. And who are these people? As I mentioned, the green card holders whose families are outside the United States, who are waiting for their visas to be processed, to be scheduled for an interview. They will be affected by this. So until such further notice. There are other people also under a different category. For example, diversity visa, DV visa. People have been applying for this. They're prepared to travel. One of them has a scheduled interview. It was canceled. Another has wrapped up his personal staff back home, they're ready to travel. All of a sudden, everything is suspended. Even though they're nurses and doctors, it doesn't matter. Third, people who are scheduled to have medical internships, they're also prevented from pursuing it as of this time. Another potential party that could be affected by this is our companies are involved in transporting essential goods from all over the world in relation to the COVID-19. They need trainees because the functions are interchangeable, so they could no longer employ people as J1s. Also au pair, not to say the least, people who attend to the children, there are families here who might need them, they could no longer engage their services. The point they're making is effectively it tantamounts to an immigration ban. Legally, it's called a suspension. Either way, these are done by way of presidential proclamations. I guess it is in consonance with this doctrine of a unitary presidency or president, but that's not within the ambit of our discussion today. It's something you could look up for yourself, but related to probably to what's going on in the news like Atlanta, Chicago, and Portland, where local authorities are complaining about the intrusion of federal authorities in police matters that are traditionally considered domestic or for states only. So I just wanted to be aware of this, and that's exactly the reason why we have this part 4. Please remember that this is not a legal advice. No two cases are the same. I could not repeat this enough. So please consult a lawyer. Obviously, you don't have to consult us, but our phone number is 212-374-9020 or 9747, or email us at ctrosio, C Charlie, T Tango, R Romeo, O Oscar, C Charlie, I International, O Oscar at trosiolawfirm.com. Lastly, excuse for my appearance today. I just came back from court. I just had to do this video for you guys. Hopefully, you'll find this informative. Beginning for further inquiries for you, especially for those people who might be affected by this. Have a nice day. Thank you.